Whew. Okay. Made it. That makes me very happy. Here we have that. And let's make a new sticky note here. Hello, everybody. I feel like I just saw several of you. Oh my gosh, I gotta move my computer a little bit closer here. There we go. Hello. Figured it out. Oh, proud of you. Yes, hello from Oregon. Thank you. Hello. Welcome in. Hi again. Good evening. Hello again, June Marie. Good evening. I'm glad you could all come over here tonight. I have been trying so hard to make my Tuesday deadlines. Last week I missed, but it seems to be every other week tends to be working out. So we'll just keep it going. If I can make it on a Tuesday night, I sure do try. Hello, Murray. Hello again, James. Angela, hello. Oh, good for you. I'm glad you got notification. Tuesdays on the tube. That's right. Good evening. Hello, everybody. Yes. Oh my goodness gracious, everyone. All right. So this is really a good one for us to do on the tube because this judge is not happy with this situation. Not happy. So tonight's case, everyone, is, let me get a thinner marker. This is the Russell case. I've been keeping my eye on it. There have just been, filings, normal stuff going on, nothing unusual. Like the Harvard case is kind of weird. They've got a lot of weird filings. But it's on this already. Everything's been fully briefed, and the court's like, you're done. We're not going to do this. So let me write down here what we have. So we have USA versus Maryland bench of judges. So stupid. Chief Judge here, Chief Judge Russell. So, this is really, there's a lot of crazy, ridiculous stuff going on here. But, wondered what you thought of it. Yeah, I'm going to dive into it for sure. I like the lives on the tube because they get saved to rewatch. Oh, yeah, I think, and they do a great job too. I feel like it's much less stressful over here. So I enjoy that quite a bit. All right, here's our case number here. I've gone through and annotated, but I tried not to peek so that we could just all see it together for the first time. It's my initial response, but there were some parts where I was like, he did not just say that. Yeah, he did. Oh my goodness. What's happening in the criminal world? It's all crazy. All right, here we go. Oh no, Kimberly, you might need to turn, well, I'm not sure if turning your mic up will help, but sometimes headphones can help too. So I am sorry about that though. Hopefully everyone can see the page okay. I've got a different kind of setup over here. So hopefully everyone's with me. Hello. Tuesdays on the tube. You got it. You got it. We've been working hard here. Before Trump has professional jurors he chooses. That's an interesting point. I'm not sure. It's a good question. I think it's a valid question, but one that we've dealt with, for centuries, for as long as we've had our jury trials. There have always been questions about that. And sometimes, I try to take us back to the Salem witch trials because I can't talk about that over on the tube. But for the witch trials in 1600s, right, we had people that were looking at evidence that was, like ghosts and dreams and stuff. So because of that, the jury was like, yeah, they're guilty. And so, even back then, it was a matter of, can we get non-biased jurors in or not? And it's a good question. Clear, can hear you. Oh, great. Thank you, Jackie. Appreciate that. Yeah, pop out and then come back in again. But yeah, that's we've got some problems. Yeah. Oh, you can watch it on the TV. Ah. Rebooted your. Okay, great. I know. It's been 2 weeks since I've been on the tube over here, but I've not forgotten. I do want to make this my permanent home, so I have some backlogs that I need to take care of. But anyway, welcome in. So, Vicky, yeah, let me give you an overview here, and I'll start diving in. I gotta get my magic wand. Speaking of the witch trials, bless them. So this case was filed last month, and it was the U.S. government after the bench of judges in Maryland, and they cited multiple cases. They're like, well, they didn't go along with us for this case, and this case. So we think they're incompetent and should be pulled from the bench, like all of them. So if you just gone in and said one, like the Chief Justice is out of control, that might have led to something. But when you go in and say, well, everybody is bonkers, that's when things start getting suspect. So that's really what happened here. They had briefings, they had hearings, and the judge came out just today with our decision here. So the judge is Thomas T. Cullen. He actually is, I believe, a Trump appointed judge. So he came in from Mr. Orange. Oh, I don't have to say Mr. Orange anymore. I can say Trump now. Yay! We love that for us. So that's what this case is about. I'm going to go ahead and dive on in. Let me know if the pages move so that I can move it back into frame again, if that's a problem for anybody. But I think we'll just kind of dive in because it's really just very well written. All right, here we go. In May of this year, Chief Judge George Russell III, could there be another name more judge-like? I mean, seriously, George L. Russell III, yikes, of the United States District Court for the District of Maryland issued 2 standing orders prohibiting federal immigration officials for just 2 business days from removing or altering the legal status of any alien detainee who had filed a petition for a writ of habeas corpus. Now, this 2 business days is important here. The court adopted these orders to address the substantial increase in habeas filings by alien detainees in Maryland, many of whom had been targeted by the government for expedited removal. That's another term here. Expedited removal puts the people who are going through that process on a different route than through the regular process. From the United States, apparently Chief Judge Russell and his colleagues were concerned that absent a brief stay, many of these habeas petitioners would be transferred to detention facilities outside the state of Maryland, and thus outside the district court's territorial jurisdiction, before a judge even had the opportunity to read their petitions, let alone rule on their claims. I'll stop here and say, I don't think this administration realizes the harm they did when when the judge said turn the plane around and they didn't. And the fact that some people have already made it to El Salvador. I don't think this administration recognizes like just how much credibility they lost in that moment. So I think that's really the key case here. And that's the JGG case, everyone, in case you're wondering. The chief judge explained as much in the body of the first order, noting that a brief stay was necessary, among other reasons, quote, to preserve existing conditions in the potential jurisdiction of this court over pending matters, while the court determines the scope of its authority to grant the requested relief. Here. Right. Page 2. In so doing, the District of Maryland effectively borrowed from the playbook of the federal courts of appeal, many of which impose temporary stays of removal when alien detainees file petitions for review and final orders of removal issued by the Board of Immigration Appeals. For instance, when an alien detainee appeals a BIA removal order, to the U.S. Court of Appeals for the Fourth Circuit, the appellate court that oversees the District of Maryland. That court typically enters an order staying removal for a period of 14 days to allow time for responsive filings and to preserve the court's ability to make a considered decision on the motion. In limiting its stay to 2 business days, the District of Maryland recent stopgap measures appears considerably more modest. Ooh, and footnote number 1, which makes sense given that Congress has limited authority of federal district judges to review immigration matters. The plaintiffs in this case, the United States of America and the United States Department of Homeland Security, collectively the executive, nevertheless took umbrage at Chief Judge Russell's actions. The executive contends that the recent standing orders constitute a direct assault on its plenary authority to police immigration matters and enforce the nation's immigration laws. According to the executive, the standing orders are unlawful for 3 principal reasons. First, the executive agencies that they are inconsistent with the federal rules of civil procedure because they automatically afford injunctive relief only to a special class of litigants, i.e., removable aliens, without requiring those litigants to satisfy the prerequisites for this type of equitable relief. Second, the executive contends that the standing orders are ultra vires or beyond the power of the courts, given the limited statutory authority of district courts to review immigration matters. Third, the executive submits that in issuing the orders, the District of Maryland violated well-established procedures for promulgating local rules of court. Fair enough as far as it goes. If these arguments were made in the proper forum, whoa. All right, we're going to get some zingers in here, everybody, all right? Oh my gosh, if they were in the proper forum, they might well get some traction. And under normal circumstances, it would not be surprising if the executive raised these concerns through the channels Congress prescribed. That is, by challenging the orders as applied to a particular habeas proceeding through a direct appeal to the Fourth Circuit, or as expressly authorized by federal statute, by petitioning the Judicial Council of the Fourth Circuit, which has the authority to rescind or modify local court rules. Oh no. The judge is pointing out like how they did this wrong procedurally. He's like, no, that's not how you do it. Oh my goodness. But as events over the past several months have revealed, these are not normal times, at least regarding the interplay between the executive and this coordinate branch of government. It's no surprise that the executive chose a different and more confrontational path entirely. Footnote 2, indeed, over the past several months, principal officers of the executive and their spokespersons have described federal district judges across the country as, quote, left-wing, liberal, activist, radical, politically minded, rogue, unhinged, outrageous, overzealous, and unconstitutional. Oh dear, it's like calling the ref a name. They don't like that. You're going to be in trouble. Oh my gosh. Crooked and worse. Although some tension between the coordinate branches of government is a hallmark of our constitutional system, this concerted effort by the executive to smear and impugn individual judges who rule against it is both unprecedented and unfortunate. Yikes. Instead of appealing any one of the affected habeas cases or filings, a rules challenge with the Judicial Council, the executive decided to sue, and in a big way. On June 24th, the executive filed a complaint in the District of Maryland, naming Chief Judge Russell as the lead defendant, but adding ostensibly for good measure every other active and senior, i.e. semi-retired, judges in the district, 15 in total, the clerk of court and the court itself. So they're after the clerk of court and the court itself, collectively referred to as defendants. In casting its wide net, the executive ensnared yeah, this judge is pretty mad about this situation. Rightfully so. Executive ensnared entire judicial body, a vital part of this coordinate branch of government, and its principal officers in novel and potentially calamitous litigations. Sorry, everybody. As you can probably see, my ink was starting to run out here. Number 3 footnote. The mere filing of this suit required the recusal of the entire federal bench in the District of Maryland and the assignment of this out-of-district judge who, by this designation, is theoretically empowered to enjoin his fellow district judges and, by extension, hold them in contempt for violating the court's orders. If the case were to survive a motion to dismiss, the parties, the individual judicial defendants and principal officers of the executive, including the Secretary of Homeland Security and the United States Attorney General, would potentially be required to sit for depositions and produce documents, including emails and other internal communication relevant to the issuance of the standing orders and the actual reasons for filing the suit. Oh, thank you so much, Bruce Wayne's mother. Appreciate that. These discovery demands, in turn, would almost certainly trigger claims of privilege, executive, judicial, deliberative process, and the like, and invariably compound this constitutional standoff into epic proportions. This is huge. I know it's a little footnote down here, but this is enormous, all right? Because they're coming in and they're suing the judicial bench, right? So that means then discovery would need to be done. And that means we get interrogatories and we get depositions and we get documents. All of the judges get this, as well as the petitioner. So discovery, again, would be opening this door to all of this information and putting it out there in public for anyone to access. So that would be huge. And I think that's an important piece to note, which is what the judge is doing here. All right, number 3, so back up, here we go. Pending before the court is defendant's motion to dismiss the executive's lawsuit. So the judges have filed a motion to dismiss, which is what this hearing is. We're on page 4 right now, right here. You should be able to see it here, hopefully. Maybe I'm not close enough. Oh, yeah. And you get a lot more bees to honey, right, than to vinegar. That I just have to say that repeatedly to myself, so I thought I would share that with everyone else. All right, here we go. Defendant's motion to dismiss the executive's lawsuit. Defendants argue that this action must be dismissed because it presents a non-justiciable dispute between two co-equal branches of government. Specifically, they assert that because the standing orders are quintessential judicial acts, the named judges are absolutely immune from this or any other suit. Defendants also argue that despite the potential merits of the executive's argument that defendants exceeded their power in issuing the standing orders, there is no right, express or implied, to litigate that grievance in this manner. Oh, thank you so much, Lori. That's really sweet. This is pretty big, right? That's a pretty big holding. As explained in detail below, this court agrees nearly across the board any fair reading of the legal authorities cited by the defendants, which again is a bench of judges, like hello, leads to the ineluctable conclusion that this court has no alternative but to dismiss. To hold otherwise would run counter to the overwhelming precedent, depart from long-standing constitutional tradition, and offend the rule of law. All of this isn't to say that the executive is without any recourse. Far from it. If the executive truly believes the defendant's standing orders violate the law, it should avail itself of the tried and true recourse available to all federal litigants. It should appeal. Like, that's what we do. All right, so number 4. Or pursue other alternatives permitted by the Constitution or Congress. Oh my goodness, this is so crazy. We're in crazy town, everybody. Statement of facts. So here we go. I'll grab some tea real quick. All right. Here's the facts, according to the judge here. On May 21st of 2025, defendant promulgated SO 2025-1. As justification, it invokes the All Writs Act, which is 8 U.S. Code Section 1651. If you see this All Writs Act piece being cited, you are 9 times out of 10 looking at a mandamus issue. Okay, so writ of mandamus is when you're asking the court to order another government entity to do something. All right, so originally in the Marbury versus Madison case, they wanted a mandamus that would force the government to give the judges their allowance to come in, right? So they had all of the appointments set out, and they were saying, you need to tell them to give us the appointments. Meanwhile, Jefferson's like, no, we're not going to do that. So just a side quest, All Writs Act, you're going to be looking 9 times out of 10 at a mandamus issue. And the limited judicial power to preserve the court's jurisdiction or maintain the status quo by injunction pending review of an agency's action through the prescribed statutory channels as the sources of its authority. And then we're quoting, by its terms, SO 2025-1 was issued to preserve existing conditions and the District of Maryland's potential jurisdiction while it determines the scope of its authority to grant the requested relief and to ensure that habeas petitioners are able to participate in the adjudication of their request for habeas relief, that the district court is able to evaluate their respective claims for relief based on their in-court testimony, and that the government has a fulsome opportunity to brief and present arguments in its defense. So the judge, again, is just saying, like, we're just asking for a couple of days so that we can take care of business here. A week later, Chief Judge Russell amended SO here. Let's look at that footnote, number 5. This amendment likely rendered SO 2025 defunct. Nevertheless, the executive continues to challenge both standing orders. So, so the judge is like, this one doesn't even count anymore, but they're still challenging it. And we have an amended standing order here, 2025-01. Oh my goodness. Oh my gosh, what are they doing? Let me see here. Let me just double check and make sure I've got the right standing order here. Okay. So ASO 2025-1 invokes the same sources of authority as SO 2025-1. And here's our complaint where he's citing the paragraph that came from and our electronic filing. So you're looking at number 14-3 for anyone that wants to get into it. In addition to asserting the same stated purposes for its promulgation, ASO 2025-1 pointed to the recent influx of habeas petitions concerning alien detainees purportedly subject to improper and imminent removal from the United States that have been filed after normal court hours and on weekends and holidays, which has created scheduling difficulties and resulted in hurried and frustrating hearings in that obtaining clear and concrete information about the location and status of the petitioners is elusive. So of course we knew after the Supreme Court came in with their decision about nationwide injunctions, that was going to be replaced by individual habeas petitions, right? ASO 2025-1 comprises 3 separate directives. First, it orders the clerk of court to docket a copy of the order after filing a petition for writ of habeas corpus on behalf of an alien detainee and simultaneously send a copy, ASO-1, of the petition and the petitioner's full name and number to the chief and deputy chief of the civilian division of the Civil Division of the United States Attorney's Office for the District of Maryland, and then file a notice that the documents have been transmitted. Second, Yikes. Effective upon the filing of the notice in a case, ASO-1 enjoins and restrains the executive from removing the habeas petitioner from the continental United States or altering their legal status. That directive remains in place until 4 p.m. on the second business day after the filing of the notice, unless its terms are further extended by the presiding judge. Finally, ASO-1 orders the executive to notify appropriate officials of this order promptly after it's docketed in a particular case and provide all necessary information and documents to effectuate compliance with this order. So these three pieces are the boundaries needed in order for that due process to be met, right? So the executive alleges that it raised its concerns about the standing orders to the judicial conference, but that defendants have made apparent that they intend to keep ASO-1 in place indefinitely. It further contends that the implementation of the orders is operationally challenging and interferes with the executive's mission to administer and enforce the immigration laws and protect public safety and national security. Since they were issued, the standing orders have been docketed in multiple cases. All right, let's see what cases they've been in. Ooh, looks like several. All right, the executive filed suit against defendants on June 24th, seeking declaratory and injunctive relief to invalidate the standing orders. Because every district judge serving in the District of Maryland is named as a defendant in this case, the Chief Judge of the United States Court of Appeals for the Fourth Circuit assigned this out-of-district judge to sit by designation and decide this case. On July 3rd, the executive filed a motion for a preliminary injunction. Defendants countered with a motion to dismiss under federal rules of civil procedure for lack of subject matter jurisdiction based on the justiciability issues, and 12b6 for failure to state a claim. Both motions have been fully briefed. The court heard argument on the motions on August 13th. After having fully considered the record and the parties' arguments, the court will grant defendants' motion to dismiss. So this is, again, remember the judges are the defendants, and they asked for a motion to dismiss, and that's been granted, which renders the executive's motion for a preliminary injunction moot, because you don't need that anymore once you've already gotten the dismissal. All right, tea time, everybody. Is everyone understanding what we're talking about here when we are just going through the history here? Hopefully. Okay. Okay, good enough. Oh, so cute. You called for bees. Bees are great. We love bees. Everybody support the bees. They're in bad shape. Yep, yuppers. Oh, great. Fabulous. It's good stuff. I'm following very well. Excellent. Oh, I love to hear it. Okay. Excellent. So we're moving on to the next piece. That was the statement of the facts. So now we need to go into the standard of review. And some of this may be just to refresh everyone's memory here when we're talking about what tests we need in order for the court to have the opportunity to review the case. So here we go. Motions to dismiss under Rule 12b-1 challenge the court's jurisdiction over the subject matter of the complaint. So we would call that a subject matter dismissal. And they're pretty much filing this, just FYI, this administration is filing lack of subject matter jurisdiction or lack of jurisdiction like almost all the cases. A defendant can successfully challenge the court's subject matter jurisdiction by asserting that a complaint simply fails to allege facts upon which subject matter jurisdiction can be based. Citing case law here, motion to dismiss under Rule 12b-6 test the legal sufficiency of a complaint. So you want to make sure you write your complaint well. To survive a Rule 12b-6 motion, the complaint must contain sufficient factual matter accepted as true to state a claim to relief that's plausible on its face. So that's one thing too. You can't just say, well, I want to sue this guy because he came into my yard. It's like you got to put some facts in there. in order for it to survive the subject matter question. All right, number 3, analysis. All right, number subject matter. I have flashes of legal. Oh yeah, there you go. There you go. I love that movie. I'm gonna watch that movie again. I've been too hooked on Sharknado, everyone. All right, number 3, page 8. Analysis. Defendants argue that the executive's lawsuit should be dismissed at the threshold for 3 independent reasons. The court agrees for the most part. The court finds that A, the executive lacks standing to bring its claim for injunctive relief, but even disregarding that critical flaw, its entire complaint is subject to dismissal because B, defendants are immune from suit. Immunity. Yep. And C, alternatively, the executive fails to identify a legitimate cause of action that allows it to bring this lawsuit. Because these irreconcilable defects mandate dismissal of an entire suit, the court does not reach the merits question of whether the standing orders are a proper exercise of judicial power. So this means, and we've had this happen quite a few times, it's too early in the game for this judge to even look at what the actual issue is. It's too early. They have not established proper jurisdiction, and so getting into the merits would not be appropriate because this judge can't hear the merits yet because the jurisdiction is not settled. To start, this is an extraordinarily unusual lawsuit. So, before explaining the specific reasons for dismissal, the court takes a moment to ground itself in 2 simple but fundamental constitutional precepts that guide much of its analysis. First, well, this judge is really into the outline format. I can appreciate that. First, the executive branch is not the sole sovereign in the United States of America. Amen. Amen. I'm going to need an amen here. Amen. Woohoo. All right. That's so good. I'm getting the yellow out. All right. I think that's really important. Let's just reread that. First, the executive branch is not the sole sovereign in the United States of America. That's right. We're going to put an exclamation point at the end. Come on. Second, the federal judiciary does not have plenary power unmoored from a justiciable case or controversy or cause of action to review any allegation of constitutional misconduct. Yes. Boundaries here, people. Oh my goodness. As the Supreme Court has explained, the framers of the Constitution sought to provide a comprehensive system that made the United States of America not a single branch, the sovereign, by dividing and allocating the sovereign power among 3 co-equal branches. And they're citing U.S. v. Nixon out of 1974. The coordinate branches together form the government of the United States of America, and together, italicized, they are the sovereign in this nation. What? That's another highlight moment here, everybody. All right, I gotta crochet that onto like a pillow or something. Wait, crochet's not the right word. You know what I'm saying? Oh my goodness gracious. Yeah, this judge is not playing around. I'm loving it. Regrettably, this lawsuit effectively pits 2 of those branches against one another. But it's important to remember that at bottom, all branches and the public officials who serve in them share the same core sovereign interest to support and defend the Constitution. And right, so see Article 2, Section 1, Clause 8, which is the President's oath. And then Article 6, Section 1, Clause 3, which is legislative and judicial officers' oaths. So based off of the oath that they take, you follow the Constitution. You don't follow anything else. You follow the Constitution, including the president, all right? Because he took the oath. And some people are like, well, he didn't put his hand on a Bible. Who cares? It doesn't matter. You don't have to have your hand on a Bible. Your oath is your oath. If you say it's your oath, then it's your oath. And he took the oath. Now, what it means to different people, that's a different issue. But he did actually take the oath. So he's bound by it. An allegation by one branch that another has encroached on its constitutional prerogative is undoubtedly serious. It is essential to our constitutional structure that each branch exercise the powers appropriate to its own department, and no branch can encroach upon the powers confided to the others. Here, the system prevents the accumulation of all powers, legislative, executive, and judiciary, in the same hands. An accumulation that would pose an inherent threat to liberty. Citing Federalist Number 4 by James Madison, and then quoting Clinton v. City of New York in 1998. I'm not sure I've read this one. I might have to take a peek at that. The federal judiciary is obviously not above those rules. In the judicial branch's case, it's vested with the ultimate supreme power of judicial review, which, awesome though it may be, can be wielded only in specific circumstances and to limited ends as allowed by the Constitution. So the Constitution is keeping that in check. Among other constitutional prerequisites for the exercise of judicial power, the legislative branch must generally authorize it. And then we've got a case here. The judicial power of the United States is, except in enumerated instances, applicable exclusively to the Supreme Court, dependent for its distribution and for the modes of its exercise entirely upon the section of Congress. And then we're citing case law again, defining jurisdiction as whether a federal court has the power under the Constitution or laws of the United States to hear a case. We hear that a lot. We hear this question of, well, you don't have Article 3 power. You don't have jurisdiction to hear the case. So this is one of their big pieces in all of their cases, is they're saying the judiciary has no role in it, and that can be pretty scary, actually. In a cause of action as whether a particular plaintiff may, as a matter of law, appropriately invoke the power of the court. This court can appreciate the executive's concern that defendants have encroached on its duty to police core matters of immigration. Citing case law, the executive branch retains discretion over whether to remove a non-citizen from the United States. I think that's really important to remember, everyone, on our journey here, okay? So this is the citation for that. If you're looking here, that's a short citation, but 599 U.S. at 679. So this is going to be the volume of the U.S. Code, and then this is going to be the page, specific page, which sets that out. And we have another bit down here. And at this early stage, it accepts those allegations as true. Again, another very important case set out as well. 556 U.S. at 678. To be sure, energy in the executive is much to be respected, and court rulings are not above criticism. And that's the Abrego Garcia citation right there. Oh dear. And then we're quoting the Federalist paper number 70 at 423, which would be Hamilton. Like any other branch's actions, a court's orders can overstep, and they can further intrude upon the prerogatives of other branches. I don't remember the exact quote of the executive branch is sovereign. Oh, that's a good question. I'm not sure. He cited the presidential oath. Yes, he did. Yes, he absolutely did. All right, but those disputes, weighty as they may be, must be resolved within the constitutional structure and with due respect for the judiciary's co-equal, italicized, standing with the executive branch. The Constitution does not give courts general oversight of other branches, Rather, it permits courts to adjudicate only cases and controversies to the extent Congress allows. Now, this I think also is worth highlighting because this is it. This is very important, and one of the things that I think a lot of people are not getting, which is that it's not the court's job to keep the other branches in check. The court's job is to adjudicate legal issues. So bringing the suits is how you check the government, but the courts themselves are coming in and explaining what the law is and whether or not it has been violated. So I think that's important to note. Yeah, they've already appealed. Not surprised. Raise your hand if you're not surprised. I'm not surprised. But this is important to note too. I think we put a lot of weight onto our courts, and most of it is outside of the realm of what their duties are. Hi, John. Oh my goodness, 7 months. Oh my gosh, that's crazy. We live in such a nutty country right now. Amen to that. That's right. I hear ya. So we've got a quote here, Trump v. Casa. I want to say Casa. Federal courts do not exercise general oversight of the executive branch. They resolve cases and controversies consistent with the authority Congress has given them. One branch's alleged infringement on another's exclusive power does not license a constitutional free-for-all. So this court must ensure that it has the constitutional authority to entertain the executive's lawsuit. When a court concludes that the executive branch has acted unlawfully, the answer is not for the court to exceed its power to. In doing so, the court's allegiance is to the Constitution. And again, I think that's another highlightable moment. All right, so just because they're acting unlawfully doesn't mean that the remedy should be outside of the scope of the powers given to the court. All right, I think that's very important to do that, to make sure that everybody's in the proper place. With those constitutional principles front of mind, and for the specific reasons laid out below, the court finds the executive suit must be dismissed in its entirety. So this is the order of the court right here. So then he's going to go through and explain the pieces. Hello, Marina. Hello, good to see you. Oh my gosh, hello everyone. Boy, we got lots of people here tonight. Thanks for stopping by. All right, so justiciability is the next piece here. And we have a huge footnote down here, number 6. So we got to make sure that we bump down because there's some interesting footnote stuff. Does a judge, magistrate always have to set out the facts on the record that they have the jurisdiction to be hearing a case? Yes, they do. They're setting out which facts they're following, right? Because they're going to have 2 different sets of facts, usually. Some things are typically what they do in their state of facts, though, is they'll take pieces from both parties and whatever's matching is what they will use. But they will set out their facts briefly and then go through and justify their jurisdiction over it, their standard of review. So they do that again just to keep everything in place and so they can go forward. All right, where was I now? I was going to read that one. Right, did that one. Okay, here I was. Justiciability. And we're back. All right. Defendant's first basis for dismissal is that the court lacks subject matter jurisdiction over the executive's lawsuit because it does not present a justiciable case or controversy. But many of their arguments do not strike the court as going towards justiciability. This is so well written, everyone. I mean, it's just like, man, this is going to be able to be used in so many cases. All right, 6, here we go. These arguments essentially make the case that the unprecedented nature of this lawsuit means that it's non-justiciable because there are other ways to achieve what the executive seeks here, citing that motion to dismiss. Here, quote, under our system of government, the executive does not just haul off and sue the judiciary, end quote. That's true. The court agrees. Yay! that this interbranch lawsuit is novel and that the executive has other means to achieve its desired end of invalidating the standing orders. But that does not necessarily mean that such a lawsuit can never present a justiciable controversy, and the court does not read any of the cases cited by defendants to hold to the contrary. So the judge is saying here, like, it's not working here, but it could work in the future. We're not saying it's not possible, but it's not going through here. And then we're citing here, it looks like a law review article from William and Mary, recognizing that the Supreme Court has never dismissed an action as non-justiciable because it could be characterized as United States versus United States, and opining that Article 3 creates no obstacles to lawsuit between two branches merely because they are both part of the federal government. Emphasis in original here, as will be discussed, that an interbranch lawsuit may be justiciable does not mean that such litigation contains no Article 3 difficulties, or that litigation is the most appropriate way to resolve the interbranch disputes. In some circumstances, the Constitution may require the unhappy branch, the unhappy branch, everybody, to take a non-justiciable route. So this is like, all right, so the judge is like, well, maybe sometime you could do this, but not this time, and I don't want to deal with it. That said, when independently reviewing jurisdiction over the executive's claims, as it must, this court did not immediately find it everywhere. And so the court undertakes its initial duty to ensure that the executive has presented a justiciable case or controversy. And then we're quoting federal courts must confirm for themselves that they have jurisdiction. That duty includes ensuring that a plaintiff has standing. On this initial review, a justiciability concern emerged in the form of standing. Standing, of course, means you can bring the suit. So if you are going in to bring a lawsuit, you've got to have your issue cannot be moot, meaning already taken care of, or not ripe. And not ripe means that you're too soon. You're coming in too soon. You need to wait. I think a lot of the cases that are going on right now, quite frankly, we've got some ripeness issues, but that's just me. But that's what we're talking about with standing. We've got a test that needs to be satisfied. So what they're saying here is our standing needs to be gone through. Now, just to give you some idea of how this works also, the court, just because you filed doesn't automatically mean you've got a good lawsuit. The court will look and see, do we even have jurisdiction? Because it's a process of elimination for the courts. All right. They're not looking at it like, well, I don't want to deal with this. They're looking at it like, which cases can we eliminate off of our docket because we don't have jurisdiction? So jurisdiction and standing are two of the ways to get rid of excessive cases that don't belong in the jurisdiction. And also, if you don't pull those cases and it goes all the way through, everything can be overturned. So we have to be really careful about that. All right, so jurisdiction and standing, hand in hand, very important. Article 3 standing is a bedrock constitutional requirement that is built on the idea of separation of powers. Its importance to that fundamental idea is plain by limiting who can invoke the judicial branch's power to those who have actually been aggrieved in a way that a court can redress. The doctrine ensures that the federal courts exercise the awesome power of judicial review only to the extent the Constitution allows to adjudicate cases or controversies. So again, when they're saying you got to follow the Constitution, right? And then you're like, oh dear, we can only follow that. What they're saying here and reminding us of is Article 3 says cases or controversies. That's pretty broad. That's a pretty broad category here to put the courts into. To establish standing, a plaintiff must demonstrate, one, she suffered or is likely to suffer an injury in fact. 2, the injury likely was caused or will be caused by the defendants. That's the causation element. And 3, the inquiry likely would be redressed by the requested judicial relief. So these are all of the pieces that we look for, not only here, but also in any kind of a negligence lawsuit. All right. And they're citing the Wells case here, quoting the Food and Drug Administration case. Importantly, standing is not dispensed in gross. Rather, plaintiffs must demonstrate standing for each claim that they press and for each form of relief that they seek. For example, injunctive relief and damages. So they have to show each one of the counts is supported, that they have standing for each piece. Oh. Here we go. So we've got a couple more cases here. The city of Los Angeles holding the litigant lacked standing to sue for an injunction, but appeared to have it to sue for damages. So each piece, you can't just have one, like when we've got standing for everything in the case, you have to show it for each of the counts. Here, injury in fact and causation seem clear. Again, these are terms that we use every day in the civil law world. Though the court has not found case law to the effect, it is no great leap to conclude that an alleged constitutional intrusion on the executive's broad enforcement discretion in the immigration context, including the discretion over whether to remove a non-citizen from the United States, causes an injury to the executive. We've got the Texas case here, rejecting a state's extraordinary, unusual lawsuit, asking a federal court to order the executive branch to alter its immigration arrest policies. Yikes. That this alleged constitutional violation was committed by members of the judiciary does not make the injury any less concrete. And that injury was allegedly caused by the standing orders. Redressability, though, is another question. To satisfy the final element of standing, a plaintiff must show that the court has the power to grant the plaintiff's requested relief and that such relief would redress the plaintiff's injury. So now we're in the Lujan area. Lujan changed everything when it came to bringing a lawsuit against the federal government. So, and here's Lujan right here. Yay! So if you are interested in the case that set out the ability to sue the government for if you've got standing, came from this case right here. Though the first two elements are most frequently at issue, redressability can still pose an independent bar in some cases. For example, a plaintiff who suffers injuries caused by the government still may not be able to sue because the case may not be of the kind traditionally redressable in federal court. And we're citing further cases down here. Gorsuch concurring, ordinarily to remedy harms like those the plaintiffs demonstrated in this suit, they would seek an injunction, but even assuming an injunction would redress the plaintiff's injuries, that form of relief is not available to them because of 8 U.S. Code Section 1252 F1. So anytime you can pull in a quote from one of the current justices, that's always good. Right. Can that be considered harassment? It's possible. We have a term in the biz, and we call it. Hold on, I just had it and slipped it out of my mind. I think. Oh, just a minute. It's coming to me slowly. I don't know what we call it. Legal terrorism is what we call it. Sorry, took me a minute, but we got it. This is one of the, I'm probably spelling this wrong. Legal terrorism is when people use the legal process and the filings in a way that just absolutely blows the other person out of the water. It's usually for something that's not actually any kind of a big deal. Like our sovereign citizens use this a lot. where they go in and file paperwork. And so you have to respond to the paperwork so you don't get into trouble, and there can be multiple filings. And it's a way of trying to use the legal system to harm another person because they're filing all of this crap pro se. And then for you, it's like, gosh, do I need an attorney? What do I need to file? Deadlines are here. So they actually use the legal system as a way to harm you. And I'm sure you could probably think of a particular person that enjoys using this particular method of harming other people as well. So that happens. Oh yes, the Off the Road series. I'm still working on that. We're going to be doing a FOIA live very soon. I've got the papers ready. But anyway, yes, I think about the off-roading series every single day and make little notes about it. Just to make sure that like there's no ethical problems for me. All right, moving on. That's the fundamental problem here, at least with respect to the executive's claim for injunctive relief. The court lacks authority to enjoin defendants. The Judiciary Act of 1789, man, I hate this Judiciary Act. I hate this act so much. I've been reading through this act and I just hate it. I hate it. This is at the same level as the Fitzgerald case. And if you know what I'm talking about. Fitzgerald. We're going to call it Fitzgerald because I hate it so much. I hate this act. I think it needs to get itself sorted out. Endowed federal courts with jurisdiction over all suits in equity. So now we've got this new term of art. And is the statutory authority that permits federal courts to issue equitable remedies, which again kind of jacks everything else up. What's it say? It says a lot of bologna sandwich is what it is. And it's in teeny tiny font, and I don't appreciate that. Oh my gosh. How are we still running our courts off of an act from 1789? I mean, that was before Hamilton was, gone. It was before the duel. We shouldn't be using it. Yikes. I'm sorry. All right. Soapbox. Now, where was I as I was going off on that? Moving forward. As the Supreme Court recently instructed that statutory grant encompasses only those sorts of equitable remedies traditionally accorded to the courts by equity at our country's inception. And then we're quoting here in so many words, if the kind of equitable relief requested was not available at the time of the founding, federal courts lack the authority to award it today. That's so ridiculous. It's got to have a highlight here. In so many words, if that kind of equity relief requested was not available at the time of the founding, the authority to award it, right. So this is jacked up pretty good because there's certain people then that would be excluded from this. But whatever. So to determine whether this court has the authority to enjoin defendants at the executive's request, the relevant question is whether the relief the executive requested here was traditionally accorded by courts of equity. Now, I'm going to take a minute and I'm going to pause again. I'm not going to go too far on my soapbox, but I am very open about, and I think it's very important for us to talk about U.S. history, our indigenous peoples here, as well as the slaves that were brought in, right? And some various other forms of slavery as well. But people are like, well, that's old school. That's history. Why do you want to make people feel bad? You know what? It's not. It's not history. When we're coming in here and we're reading cases that are coming from the 1800s and we're using laws that were set out in the 1700s, I don't think that slavery should be off the table. I think it's important. Or, how the indigenous peoples have been dealt with, right? So that makes me very frustrated when people say, well, we don't want to talk about that. All right, well, tell the judges that. Tell the judges that, because I've got a 1700 Act in here. I've got a handful of cases from the 1800s. So if the judges can cite an 1800 case and a 1700 law, I think we should be able to talk about slavery. I mean, that's how I feel about things. All right, that's my second soapbox. All right, here we go. Going back into it. Drives me crazy. The answer is a resounding no. The Supreme Court's resuscitation of history in Pulliam v. Allen provides that answer. There, an otherwise fractured Supreme Court agreed that at the common law itself, there was no such thing as an injunction against the judge. Right. All right. That's a 1984 case. Suits for injunctive relief against a judge could not be maintained either at English common law or in English courts of equity. And even the equitable remedy for the court, found to be a common law parallel to Section 1983, which is civil rights injunction, at issue there, the king's prerogative writs were never used against judges of the sovereign courts. The King's Bench was successful in insulating its judges from collateral review. At bottom, it appears that nothing like injunctions against a federal court or judge was available at the founding, so under the Judiciary Act, federal courts lack authority to issue them. That is out of one of our Trump cases. Boo! Get off the stage, Mr. Orange. So that's not cool. The requested equitable relief, in other words, a forbidden one in this case, giving the executive an insurmountable redressability problem. Yep. All right. And then they're citing Gorsuch for some reason. I think Gorsuch needs to be cited in order to feel good about himself. And I think that lower court judges recognize that. So that's why a lot of them are like, here, Gorsuch, we're citing you. You're so smart. Is he that smart? I don't think so. Nope. Accordingly, the executive lacks standing to pursue an injunction, and its claim for relief to that effect will be dismissed for want of subject matter jurisdiction. I mean, that's what it comes down to. How does the United States of America have standing to sue a bench of judges, right? And we've got footnote 7 here. To be clear, though defendants never argued that the executive suit was non-justiciable, for this reason, the court's independent review of standing was prompted by both parties' discussion of Gruppa Mexicano and Trump v. Casa at the August 13th hearing. Defendants cited the rule emanating from those cases in the context of its argument that the executive lacks a cause of action and judicial immunity, and the executive did the same when arguing the merits of why defendants' standing orders were unlawful. Even though this rule was never raised in the standing context, it nevertheless requires the court, under its independent duty, to ensure that it may use its judicial power to find that executive lacks standing to pursue the injunctive relief it requested here. In addition to the court's inherent equitable powers, the executive asserts in its complaint that this court has the statutory authority to issue the requested injunction under the All Writs Act. But the Supreme Court rejected the same type of argument in the Gruppa Mexicano case. All right, well, that's getting into the weeds. Let's get back up. Let's go back up here. Here we go. That said, the same flaw does not extend to the executive's prayer for a declaratory judgment. Now, remember, prayer just is that ask at the end of a complaint, right? So we just use that term prayer still because, apparently we use stuff from the 1700s still, which is a congressionally created remedy that could redress its injury here. Right, that means the court will not dismiss the executive suit on this basis alone. Even if the executive had standing to pursue the requested injunction, however, its entire suit, including its request for declaratory judgment, would be dismissed under the doctrines of sovereign and judicial immunity for the reasons discussed below. Accordingly, the court ensuing discussion on immunity doctrines, and after that, the executive's lack of a cause of action, applies to the executive's entire suit. Oh, Kristen, hello, Kristen. Hello. Certainly does. Well, right. Exactly. All right, so let's dive into immunity. I'll probably hit immunity and then kind of fast forward after that. But anytime we have immunity discussions, I think it's important that we pull those out because the immunity issue just can't be brought up enough for everyone. All right, so here's B, immunity. Apart from their justiciable concerns, defendants argue that this suit can go no further because the district court itself possesses sovereign immunity, and the judges and the clerk of court have immunity for their official acts. The court agrees. Now, this is huge. This is where we have the like prosecutorial misconduct issues going on. Here is that there are some situations in which things have gone too far, and so people involved in the court system can be called out on it. But those are like so few and so few that it's barely used at all. But you're not going to take off a whole bench. Usually, if you're suing for something like that, it's going to be a one-on-one situation, right? Or again, the prosecutorial misconduct that can go down the ethics road or even the criminal road too sometimes. All right, sovereign immunity. Let's learn about it. Yay! Oh, absolutely, Beth. Happy to do it. So sovereign immunity here. Let me make sure my page is in frame. Okay. Here we go. The United States District Court for the District of Maryland, as an entity of the sovereign United States, is immune from suit, and the executive's claims against it must be dismissed. Few rules are more settled in this nation's body of law than the jurisdictional rule that the United States may not be sued without its consent. This was so huge. Oh, look at this, another 1850 case. You know, that again, look at this. We got an 1850 case that's being cited to. All right. So that's important, right? I mean, that's 16 years before the Civil War. As a federal court created by Congress, the United States District Court is part of that combined sovereign that may not be sued absent congressional waiver. And this is another case here, collecting cases. And we should see Bivens in here pretty soon. Hold on. If anybody sees the Bivens case, give me a heads up on it. Observing that government entity is entitled to sovereign immunity unless Congress waives that immunity and authorizes consent to suit. Rather than attempt to identify a statutory waiver, the executive's arguments against sovereign immunity here rely on a logical fallacy and half-true citations. That's what I'm saying with the citations issue to case law. Accordingly, the court comes to the unsurprising conclusion that the United States District Court for the District of Maryland is entitled to sovereign immunity and will dismiss the executive's claims against it. So here we go. We've got footnote 8 down here. The executive argues that because it can identify cases where federal courts were sued and those cases were not dismissed on sovereign immunity grounds, that means the district court here is necessarily not entitled to sovereign immunity. That is that's an elementary logical fallacy. Ooh, ouch. That's a burn. Here, the court rejects the argument here, and everywhere else the executive makes it. What? They did not just say that. Hold on, everybody. That's hilarious. The court rejects that argument here and everywhere else. The executive makes it. Oh my gosh, that's so funny. That's right, Judge. The court also rejects the executive's reliance on Strickland in this context. It argues that the Fourth Circuit held Strickland that the court itself and its chief judge did not enjoy sovereign immunity for claims that had acted beyond the scope of their powers and or in an unconstitutional manner. Here, fast forward, that's only half right. Strickland's quoted holding applied to the official capacity defendants, which did not include the court itself. Nice. All right. Accordingly, the court comes to the unsurprising conclusion. See, I got it that time. That the United States District Court for the District of Maryland is entitled to sovereign immunity and will dismiss the executive's claims against it. So, boom, we have immunity. That means, we're good to go, like proper immunity. And then there's judicial immunity here. This acts very similar to what we see with a lot of police officers, right? In that kind of immunity, and also prosecutors, and because you shouldn't be getting sued for doing your job. A lot of 1983 questions, 1983 actions are a violation of civil rights. So probably the most recent one that I could remember is the one in DC against Trump, where there was a 1983 civil rights violation for messing around with people's votes. So that's definitely on the table here. So I'm going through that. Uh-oh, did I miss Bivens? I probably already did. If I miss Bivens, it means it's not that important to me. Ooh, the Buckley case. That's a good one here. What do we got? Gibson, Bradley. Here we go. Gibson again. Yeah, that's it. Hamilton. Okay, that's it. So I just fast forwarded through that. And I bet Bivens was in there. Sorry, everybody. I'm on a Bivens rant for the moment. The Bivens case is the old school case that says when you can sue the government. It's an old school test. The Bivens case for me is hilarious because it's like Bivens and 6 unknown federal agents. Like, that's the name of the case. Who writes that? All right, here we go. Back on target. Back on target. Messing around with people's votes. Yeah, exactly. All right, C, lack of cause of action. So we had immunity, that was taken care of. Now we're looking at lack of a cause of action. Defendants also moved to dismiss the executive's lawsuit because it does not identify a cause of action that allows it in the first place. The court again agrees. Dismissal of the executive suit's appropriate because it has not pointed to a cause of action that permits this court to entertain a lawsuit between two coordinate branches of government. And this court will not be the first to create one. Oh, nice. Nice. That's what we like to hear. It is axiomatic. Please, come on. You didn't have to use that word. You could have just used a regular word. It is axiomatic that, separate and apart from justiciability and jurisdiction, a plaintiff must have a legally cognizable cause of action to involve a court's judicial power to review a given case or controversy. And then we're citing the Davis case here, instructing that the cause of action question asks whether a particular plaintiff may, as a matter of law, appropriately invoke the power of the court. And then we have another quote here. Ooh, Egbert. Ooh, that's a good one. What are we quoting out of Egbert? Let me back up a little bit. Egbert fascinates me. So here we go. We've got this one still here. All right, it is still firmly established in our cases that the absence of a valid cause of action does not implicate subject matter jurisdiction. Congress, as the branch responsible for deciding what cases or controversies a court may decide, generally creates these causes of action. Now, the Egbert case, I recommend reading this one because it's a bit of a controversial case, and it's just very interesting. Let me make sure that I've got the right set of facts in my head. Sorry, everyone, just 1 minute. I'm going after Egbert. Egbert, where'd you go? Egbert v. Boulay. I think that was a Scalia decision. Let me just double check here. Supreme Court, which the court decided to extend the Bivens case. Oh my goodness, everybody. Can you even believe it? This case, all right. I'm sorry, I'm very excited. All of a sudden, over Egbert. I'm such a dork, everyone. All right. So this case, this was the Smuggler's End case. All right, so let's pause. We'll do a quick side quest. So there was a dude, and he lived really close to the Canadian border, and he had like a guest house, bed and breakfast situation. All right, he was an inn owner. Now, there had been some deals between him and the feds where he would like help the feds out. He'd kind of give them information and some stuff. Well, there was a new federal officer that came in and was like, "Hey, what do you know?" And for some reason, Egbert like went bonkers and was like shooting at him, and they were shooting at each other, and then ran away. This is the long and short story of how this thing went down. Okay, there were a lot of damages that came from this little fight that they had, but then Egbert was like, "Hey, I've been working for you guys, you're not treating me right." And meanwhile, Boole is getting thrown to the ground. He's like, "I'm a federal officer, why am I thrown to the ground?" So Egbert's like, "I'm gonna sue." And based off of the Bivens case that I've already been talking about that we haven't found, the lawsuit would not have covered this set of facts. So what they did in Egbert was they actually extended the Bivens case. All right, so very exciting, very exciting. And what is the question? Does a plaintiff have a right to sue federal officers for First Amendment retaliation claims or for allegedly violating the individual's Fourth Amendment rights while engaging in immigration related functions? Here's the conclusion. A plaintiff does not have a right to sue Border Patrol officers engaged in immigration related functions for the First Amendment retaliation claims or for alleged excessive force. Oh, it was Thomas. It wasn't Scalia. I knew it was one of the slimy ones. Justice Clarence Thomas authored the majority opinion for the court. So, although Bivens permits suits against federal officials for excessive force under the Fourth Amendment, its application to Border Patrol officers raises national security concerns. So they're making this clear distinction between law enforcement and border people. Yeah. Right. Yeah, I know. Okay, so the Egbert case, the Egbert case is a big one here. And it's interesting because he was like a smuggler and he was doing everything, on the down low. But a new Fed came in and he's like, I want more money. And then things go sideways. So Egbert v. Boole here, and then the Bivens case. And if you just put Bivens in, it'll pull that case out for you. All right. I feel like, I've been validated now that we've gotten to the Bivens case. All right, keep moving forward. Move forward here. And though courts have occasionally implied causes of action to allow an aggrieved plaintiff to sue for alleged constitutional violations, that practice has gone by the wayside. To appreciate more fully the tension between judicially created causes of action and the Constitution's separation of legislation and judicial power here. And we're quoting up here. I'm just like making sure we're still on target. For under those constitutional norms, creating a cause of action is a legislative endeavor, and a court's authority to do so is at best uncertain. All right. Again, the reason I bring up Egbert and Bivens is because, you have to go through some serious hoops before you can even bring a lawsuit. So they have to give you permission to sue them. Which who does that, right? Here it is. Look, Bivens is here too. All right. Enough with the Bivens, everyone. I just am narrowed in on this. John Oliver has an excellent piece on the Bivens case if you're interested. All right, fast forwarding. Oh, here's another piece that I thought was interesting. Again, we're just kind of going through right now the different levels of immunities and if there is a cause of action here. One piece, though, that I thought was interesting was the judge was having a hard time here trying to figure out the record. So in a footnote, he put, tracking down this order was no easy task, and the court thanks the Fourth Circuit Library for its aid in finding it. The referenced order is attached as an appendix to this opinion. Very rare. This is very rare. A judge is thank you to the library, right? So I thought that was really cool. And fast forwarding still, cause of action still here, everyone. Let's fast forward here till we get to our conclusion. Okay, there you go. So that was the last piece. And here's our conclusion. All right. In their wisdom, the Constitution's framers joined three coordinate branches to establish a single sovereign. That structure may occasionally engender clashes between two branches and encroachment by one branch on another's authority. But mediating those disputes must occur in a manner that respects the judiciary's constitutional role. And that's in the Casa case that was just handed down. As Judge Wilkinson aptly noted in a case posing a similar, though less direct clash, quote, a reciprocal respect for the roles of the executive and the judiciary may be too much to hope for in this most fraught and polarized of times. But it remains the only way that our system of constitutional governance can ever hope to work. And we're citing cases here. The Abrego Garcia case we're citing here with his concurrence. Much as the executive fights the characterization, a lawsuit by the executive branch of government against the judicial branch for the exercise of judicial power is not ordinary. The executive's lawsuit will be dismissed and its a motion for a preliminary injunction denied as moot. Whatever the merits of its grievance with the judges on the United States District Court for the District of Maryland, the executive must find a proper way to raise those concerns. The deputy clerk is directed to forward a copy of this memorandum opinion and accompanying order to all counsel of record, entered the 26th day of August by the Honorable Thomas Cullen. So there we go, everybody. We skipped through a couple of pieces, but I think that was okay. I didn't want to go too far into the weeds of this, but so yeah, I think our judge here was pretty clear. Like, you know, we're not supposed to be battling the other branches. I agree. Yep. Moot seems appropriate. Yeah, I agree. Geeking out about a signing law. Oh my gosh, Willie B, I tell you what. For some reason, that Bivens case just gets me every time. I think it's because it is so, like, they just don't listen to me. Now I'm getting back onto my soapbox. Look, the Bivens court screwed stuff up. I'm going to say it straight up. They screwed stuff up, and it's very difficult to actually apply the Bivens case. Very, very difficult. And so Egbert's not really that helpful, but it is interesting because he was a smuggler and he had a license plate on his car that spelled out smuggler. So he had these federal agents always coming to his inn on the border, and he'd be driving around in his car that said smuggler. Everybody knew what was what on that, but it's interesting. People are weird. People are weird for sure. Yes. These are the last of my summer nails, everybody. Oh my gosh. I'm ready though. I'm ready for fall. I'm ready for fall. All of the apple pies, I'm ready for it. Pumpkin spice, bring it on. I'm ready. Will never be appropriate ever. That's a good point. And the solace that I take, truly, because my closet is packed right now. I need to get another board. The solace that I take from it is that, you know, the pardon ability of this president is going to make or break his history, truly. I mean, if he's going to go through and pardon anybody who did some kind of criminal action, I mean, that's really where we're going to see history made. And of course, you know, we've been talking about the Epstein situation, right? He starts pardoning people in that. I mean, oh my goodness, the heads are going to roll, in my humble opinion. My humble opinion. So, is that why they've been? Well, right, exactly. So this was the case for tonight, everybody. I think we, so not ready. I think we've covered this pretty well. Again, this came out just today. I know Mr. Popak on Legal AF has also a piece. I've not listened to it because I didn't want it to change my opinion. I wanted to get the first impression from reading it here online. I've not seen it yet, but that's on my to read list or to watch list. As well as John Oliver. Oh my gosh, everybody, have you seen his posts recently? Again, I like a little humor with my doom and gloom. And my goodness gracious, he's doing great work over there. So, highly recommend. Go catch John Oliver on YouTube. He just does great work. I got really hooked on him after I saw his presentation on SLAP lawsuits. So he just did such great work. I'm like, yep, that's the one. So they do pretty good work. Oh, John Oliver, I know, right? Right. Fall's coming here in Oregon. Oh, I know. We're gonna make it through. We're gonna make it through. We're in tough times, but we just keep going forward. So I will again. Tuesdays are my for sure dates on the tube, but there's a lot of things happening here on my tube. So beware if a whole bunch of stuff keeps getting kind of like it gets put up. But I'm having a really good time. I'm really excited about some of the new fun stuff that it's only for over here. It's only for the tube. So hopefully you can come and join me next week, everyone. And I do see all the comments from any of the posts that go up. So feel free to comment as much as you like. It's a lot easier over here for me to get an answer to you. So yes, three. Oh, I know. They'll go fast, Dania. Beach, Florida girl. I'm sorry about that. But yeah, they'll go fast. I think we're already seeing that a little bit. So I think we've got some interesting things coming up here in the next 6 weeks. We're going to see some changes happening, in my humble opinion. So also, one more side note for those that have been watching the Blessing Game case, the Blessing Game lawsuit of the officers and people that brought a lawsuit against Trump for harms that were done to them during Jan 6th, still going, still up and going. They cannot get it dismissed. The judge over and over and over again is like, we're not dismissing, we're not dismissing. So again, we had just another filing a couple days ago, which was a joint update on what's going on, and they're working through discovery. So I think it'll be very interesting to see what happens. Legal ethics class. Well, yeah, some things you just got to do it. So how many spells I cast? Unknown number. Well, have a great night. Thank you so much to the moderators. You're amazing. I always love coming over here because it's just so chill and we can just talk. So I appreciate all of you so much. And thank you everyone for coming by. I'll head out now and see you all again very soon.